Hi and welcome. Today we are joined by Sarah Green of the Law Commission for Commercial and Common Law in England and Wales, and also we're joined with Sam Quickie from Linklaters. Let's ask Sarah please to give a brief introduction about yourself and explain what the role of the Law Commission is, please.
Okay, thanks, Ian. So yes, I am the Law Commissioner for Commercial and Common Law at the Law Commission of England and Wales. And essentially what the Law Commission of England and Wales is tasked to do is to ensure that the law of England and Wales remains fit for purpose. And there's all sorts of reasons, of course, why a law might not be fit for purpose. It might be that it worked well for hundreds and hundreds of years and no longer does, given social and technological advances. And that's certainly the reason that underpins most of the Law Commission's projects at the moment, and I'll talk a bit about those later on. But essentially, the important point to note is that the Law Commission is an independent body. So we stand apart from government, and when we do a project and we propose law reform, we do so on the basis of consultation. So asking anybody who might be affected by that law or who has an interest in it, maybe it's academic, maybe it's practical, to tell us what they think about our proposals. And that's the process we go through really in order to come up ultimately with reform proposals for government.
Thank you very much. And then if I could ask Sam to give an introduction of yourself and what's your focus at Linklaters.
Thanks very much, Ian. Yes, so I work in the capital markets team at Linklaters, but with a strong focus on fintech and blockchain sort of deployments in the industry. So over the last few years, we've been increasingly involved in big sort of enterprise grade projects that have used or looked to use distributed ledger technology and blockchain, and in many ways of revolutionizing key aspects of the capital markets market. And so we obviously we spent a great deal of time looking through the proposals from the Law Commission, or actually just the paper, because at this stage there are no full proposals, and looking at how it would apply in our market and how it sort of would impact some of the tentative conclusions that we had already reached, you know, by thinking about some of these issues, obviously not all of them, but some of them ourselves. So we were involved back in 2019 with the UK Jurisdiction Task Force legal statement, and we had sort of helped to coordinate that and liaise with some of the barristers involved in writing that statement. And in many ways, we see that the work of the Law Commission is sort of following on from that brilliant piece of work from the UK Jurisdiction Task Force. And so it's great to see sort of these things are progressing, and we very much look forward to further developments over the next year or so.
Well, thank you both for that. And let's turn to Sarah first to discuss, as Sam's mentioned, the call for evidence regarding smart contracts that the Law Commission has put into the public domain for consultation. So perhaps, Sarah, if you could sort of set the scene around the thinking of the Law Commission, perhaps give a brief definition of smart contracts and what are you seeking to achieve in terms of outputs objective?
Thank you. Yeah, so we've had the call for evidence out for a number of months. It's now closed and we're analysing those responses, but it's by no means the end of the process, because what we do now is analyse those responses and produce a scoping paper. So we don't always go as far as producing concrete reform proposals to government, or at least we don't always do that in the first instance. And this is an example of a project where, as Sam says, we're really laying the groundwork and finding out in the first instance what it is we actually have to look at further. So the questions in the call for evidence in relation to smart contracts were really about trying to identify what users were doing with smart contracts, if anything. We encountered quite a few initial responses from people saying, oh, well, smart contracts are still highly speculative, nobody really uses them. And of course, that isn't true at all. And so that was one of the things that we unearthed and we wanted to unearth with the call for evidence. And then a step on from that is what those users have encountered in terms of any legal problems. So does the current law of contract serve those users well? Does it? Sam's already referred to the UKJT statement on smart contracts, which concluded that they were perfectly, or rather the law was perfectly capable of accommodating them. And I think that's right. And we really wanted to take that further and go into the detail of just how that would happen. Do there have to be any tweaks, any modifications? So we have this fantastic toolkit in the law of contract, and the questions in the call for evidence were really focused on the extent to which that toolkit could be used as it is, or whether we had to add anything to it, or, as I said, sort of modify or tweak any of those tools. And what we wanted to do, and it's really important to the Law Commission, is to ensure that we have a practical perspective on that. So we really did want to hear, and we have heard from those who use these contracts, so that we don't just produce a scoping paper, which is based on a sort of theoretical idea of what we might think the law needs to do.
Well, thank you very much. So I was just reminded, I believe I've heard Vitalik quote that he wishes he never used the term smart contract. He perhaps should have used something like self-executing code, which is a lot more of a mouthful, because a lot of people out there just see smart contracts and think that it fits into contract law, as you stated.
Yeah, sorry, you did ask me about that, didn't you? And it was actually one of the most difficult things. We asked everybody, what do you understand by the term smart contract? Because obviously we set out the idea that it was a subset of smart contracts that we were interested in, because we're only interested in those that are legally enforceable. But it was a surprise to me. I mean, not a huge surprise, but I was surprised by the extent to which there was disagreement about what smart contracts actually means. I think every single stakeholder we spoke to had a slightly different idea of what they meant by smart contracts. So for instance, and I'm going to let Sam talk on this a bit more, but for instance, I think the biggest sort of thematic disagreement was whether a smart contract had to be one that was on a distributed ledger or not.
Yeah, even the clarifying what a smart contract is a challenge. And I'll now hand over to Sam to sort of discuss some of the good work that he and his colleagues at Linklaters have done in terms of their response to this consultation. And we know from a summary of the response, Sam, that you came up with 5 conclusions. Can you speak to these and sort of talk around that, please?
Yeah, for sure. So I'll just summarize the 5 key conclusions and then go back through them in a little bit more detail, just to talk to them a bit more. So firstly, so touching on Sarah's point just now, one of our main conclusions was that we didn't think that DLT should be treated as a key defining feature of smart contracts. I'll come on to why that is in a minute. Secondly, we considered that self-executing contracts are not necessarily a new development. Thirdly, we thought that actually code alone, just on its own, without anything else extraneous to it, can't really ever amount to a legal contract. Fourthly, we came to the conclusion that decentralized multilateral arrangements, such as those that you typically see in the sort of Ethereum context or other DeFi contexts, will often fail to amount to legal contracts in the absence of a sort of detailed rulebook that everyone who's using the arrangement signs up to. And in light of those sort of first 4 conclusions, our overall sense was that there wasn't really a case for a fundamental change to contract law. So I'll just go through those in a bit more detail, so we can set the scene a bit more. So firstly, DLT shouldn't be seen as a defining feature of smart contracts. So we have been involved in projects over the last few years that are using both sort of DLT, decentralized technology, and centralized technology, and we are aware of there being some coding languages such as DAML that are designed for both. And so we sort of thought that actually the useful absence of DLT in any one of these deployments for a smart contract shouldn't be a determinative influence of the legal analysis as to whether a contract exists or how it should be interpreted, but rather it will depend on the circumstances and facts of each case. And DLT is a very exciting new technology, but we think that the concept of smart contracts is broader than just those implemented DLT. Secondly, self-executing contracts, we don't see those as a new development. So smart contracts, in the sort of loosest sense of the term, as a sort of self-executing piece of code, have in our view been around for a while. And one example of that, I think, is the financial markets trading arrangements, where participants will sign up to a sort of multilateral rulebook, often drafted by a central counterparty or a trading venue. They'll input some trading data, and then an algorithm will route trades and orders and agree and spit out contracts. There's no natural language that sits behind those algorithms. It's just an outcome-based system, and we see that as being effectively a smart contract, although obviously a much more basic one. Thirdly, in our view, code alone can't amount to a legal contract. This is a sort of slightly tricky one to explain in some ways, but I think this is consistent with the UKJT legal statement. But for there to be a contract, you need several key things under English law. You need agreement, consideration, certainty and completeness, intention to create legal relations, and certain formalities as well. There just being a piece of code that runs automatically on a ledger, we just don't think that can ever amount to a contract unless you have some of those other factors extraneous to that code. So in our view, the two main types of smart legal contracts, which I think what the Law Commission is most interested in, are the internal model and the external model. And by that I mean the internal model where you have a natural language contract where some or all of the obligations are performed automatically, but they don't sit within the actual contract. They're just how the contract's performed. And then the other model where you have a hybrid, where you have a natural language contract that you or I would be able to understand easily, but some elements of that contract are actually in code, and that's similar to the financial markets example that I gave earlier. So that we think those are the two main types of smart contracts, and just code alone probably wouldn't be enough to amount to a contract in our view. Fourthly, the decentralized, so in a DeFi context, it can be very difficult to see how people involved in a decentralized network could be said to have always at least have an intention to create legal relations. There's so many different participants involved in one of these setups, and it's not always clear like who the counterparty is, what the terms of a contract might actually be, and whether there is actually any intention to create legal relations. And if you think about it from a practical perspective, that's probably the right outcome, because if you're a coder on the Ethereum network, or you run a node, you probably don't think that you're not expecting to be entering into legal relations where you'd be liable if you, for instance, stopped, I don't know, running the script. But that doesn't mean to say that if you're in an enterprise context and you're trying to provide a decentralized framework at an enterprise level, and you really want everyone to enter into enforceable legal arrangements, if you have a rule book and a set of rules and common codes that everyone signs up to, then it's much more likely that you'll have a legal arrangement there. So I'll just quickly summarize our last conclusion, which was that we didn't see really there being any fundamental case to change the law. I think we just felt that there are some novel arrangements that arise as a result of smart contracts, particularly in a DLT context. But we think that the current principles of English contract law can largely cater for those novelties, and the great flexibility of the English legal system should be able to manage with these. There are a couple of edge cases where, in our response, we thought actually, yes, this could do with being clarified, but largely they're related to technical legal points, such as the formalities for something being a deed or execution formalities. So I'll stop there, and apologies for going on for a while, but yeah, it's a really interesting topic, and we did have a lot of detail on this one. So
yeah, thank you. No, thank you very much, Sam. It's a very in-depth topic, and I'm sure Sarah and her colleagues have got a lot of reading to do over the next few weeks. But if I could follow up, Sam, with a question, just based on your experience operating in the corporate law space, have you seen any test cases anywhere in any jurisdiction where perhaps code has failed and one party has been left out of pocket, for example? You know, what's the recourse in any restoration?
Yeah, so it's a really interesting question, and I mean, being totally honest, I'm not aware of a formal test case where that has actually transpired, and I did actually ask around the group more generally to see if anyone else was aware, and it just hasn't come to our attention yet. But completely appreciate there may be something out there, but it's definitely a risk, and it's something that we discussed in our submission, and it sort of goes to there are various things you can obviously do to mitigate that risk, and one of them is to have the outcome of a code actually formally audited properly, so that you know what the eventualities are going to be in almost all cases. And I think we can definitely see that being a practical way of mitigating that kind of risk for people who really want to do this properly and implement it at an enterprise level. But it does create, it's going to create a market for entirely new service providers, and it may not be something that lawyers are actually able to do. So I think it's very much a watch this space, and it's very exciting.
Yeah, thanks for that, Sam. And I myself haven't heard of any cases brought to court. I do know of examples. I'm not going to name any names of projects in the DeFi space where perhaps a smart contract has failed and locked up somebody's assets, and they haven't been able to remove them. And in terms of the code audits, there's not that many players out there. Trilobits are one of the main ones in the US that do good work in auditing smart contract code and other enterprise blockchain or public blockchain code for companies that want to launch a product. So this is groundbreaking work, Sarah. So let me ask you, in the UK, the Law Commission and UK law has a great reputation globally. Are we ahead of the curve, and what are you working with colleagues overseas on this?
Well, we certainly keep an eye on what other jurisdictions are doing, both in terms of any reported cases that they have, and we certainly have informal conversations with our counterparts in other jurisdictions, because I think, it's impossible to do a sort of joint project, if you like. On the face of it, that might look like the ideal solution, but of course you can't really do that just because of the very different rules and laws within each jurisdiction and the different customs and what's already there. So sadly, we couldn't do anything like that. But equally, it would be, inauthentic to pretend, of course, that this can be resolved in any unilateral way, because these are things which are by their definition global. So the approach that we've taken instead is to have informal contacts and sort of progress reports with other bodies that are thinking about these issues. And I, for instance, sit as an observer on a couple of other bodies that are considering law reform. They're not exact, I suppose, analogues for the Law Commission of England and Wales, but they perform much the same purpose. So we observe what each other is doing. And I think we are, even without that, I don't know whether it's surprising or not, but there's actually a remarkable amount of consensus about what needs to happen, despite the differences, the sort of innate differences between those jurisdictions. As to whether we're ahead of the curve, I think we're probably, and I only have anecdotal evidence for this, in terms of smart contracts, we're certainly, there's no other jurisdiction that I'm aware of that has made legislation, for instance, on the sorts of issues that we're thinking about yet. And I think, and this sort of fits with something that Sam was just saying, and that we heard very helpfully from quite a few responses to the consultation, is that it's a case of really being aware, waiting to see what issues are thrown up, and sort of preparing the law to be flexible in a way. So that doesn't really lend itself very well to legislative change, because of course legislative change is in some senses seismic, and it takes a very long time. And so making legislative changes at this stage, which is, I suspect, why no jurisdiction has really taken leaps and bounds on this, it seems a bit premature because we're still not exactly sure what those changes need to be. So, as I said, what we're doing at the moment, combined with the UKJT statement, it's about saying, what does contract law do at the moment? There is a strong sense, I think, that it is capable of dealing with smart contracts, but that some definitions and understandings of concepts will have to change. So we have, Sam referred to formation formalities. So, you know, we still need offer and we still need acceptance, if you want to see it in those terms. But that offer and acceptance might just look slightly different, or in some ways maybe quite different in a sort of physical, factual sense to how it looks when you have two human beings who are talking like this maybe and coming up with an agreement. So I think the legal concepts are the same, but we just need to be prepared to be responsive and quite flexible in terms of interpreting what those concepts mean in a smart contract context.
Thank you, Sam. I heard you say on a previous podcast that we need to have flexible walls here. And that's kind of where I see a lot of the policy and regulation. That's what we work on to achieve guardrails that are in place to protect against consumer harms. But let's ensure that we don't over regulate or release law that is prohibitive to the development. All right. Well, I'm going to put you both on the spot and ask a crystal ball question, if I may be so bold. So firstly, to Sam, where do you think what do you think the law would look like in, say, 5 or 10 years? And you touched on code audits. What else do you think will be in play, Sam?
So if we're just talking about smart contracts and leaving aside the digital assets and crypto assets, because I think that is a completely different area, and we'd probably have a whole another session to discuss that. To be honest, with smart contracts, I honestly think it may well stay pretty similar to what it is now, subject to Sarah's thoughts, to be honest. But I think it. I think Sarah's right. I think the English law can currently deal with quite a lot of the novelty, and it's always traditionally been very good at dealing with novelty. I do think there will probably be some quite targeted amendments to existing legislation, but I think certainly from a legislation point of view, I would be surprised if there was anything too drastic. I think there will be a lot of court cases though over the next 5 to 10 years, and I think that will be really, really interesting. And I think it's probably too early to tell where those kind of things will end up without sort of there being test cases or actual sort of proper disputes at the moment. But I think most of it will be driven by the courts rather than the government and legislators.
Thanks, Sam. And naturally not wanting to front run your guidelines that you will issue later, Sarah, and I know you've got a lot of work to do. So sort of from your view, maybe philosophically, what would you like to see as the ideal solution for us in the UK and globally?
I think what is likely to happen, particularly in the time frame you mentioned, so the next 5 years, which of course certainly in an English law sense is not very long at all. It's not known for changing particularly nimbly, which in many ways is obviously a very good thing, and certainly in contractual terms it's a very good thing because parties then know where they stand. So we should not criticise that too much. I think in the smart contract context, so you reminded me what I said in that previous podcast, which I think was something about solid foundations, so that the concepts stay the same, so that parties do have some continuity and they know exactly what is demanded of them in a strict legal sense, but then have these flexible walls so that exactly what those concepts mean can change and can adapt to the sorts of commercial and also, I suppose, consumer, it'd be increasingly consumer as well, context that it has to apply to. And so my sense is what will happen in the first instance, I mean, I agree with Sam, a lot of this is going to be worked out in the courts. And one of the first consequences of that, I think, is that we will see a lot more soft guidance from particular industries themselves and particular sectors themselves. Because, for instance, we have a whole raft of consumer legislation that says what traders can do when they're contracting with consumers. And of course, there's no reason why that would not apply to a smart contract with a consumer. And a lot of that is about transparency, it's about fairness, it's about making consumers aware of what they're agreeing to. And what I think will happen is that there will be a lot more use of, say, protocols or best practice within a given industry, so that they decide amongst themselves, you know, maybe what is the best way of making this term or this clause transparent for consumers, making sure they know what they're doing. And I think that parties will start to work it out for themselves, and there will eventually also be a library. Well, I mean, there already is to some extent, but I think there will be a greater use of libraries of code, so that you start to get standard terms, but actually standard terms that work in consumers' favour, because they can become more familiar with those rather than being caught out by code with which they're not necessarily going to be very familiar. So I think it's going to be a sort of soft law change over the period that you refer to, Ian. It may well be that over sort of 20 years, we might see more legislative change as some of these problems work themselves out. I think that's probably my best guess.
Well, thank you both. It's always a difficult question. I'm not going to offer my thoughts because I would completely butcher it. But that brings us to a close. So thank you so much for joining us today.